In workplace discrimination news, a U.S. appeals court, namely the Fifth Circuit Court of Appeals that governs Texas, among other states, has adopted a revised rule that makes it easier for people to prove workplace bias claims. So they have abandoned a rule that made it more difficult for these claims and says, okay, now we're going to make it easier to show these workplace bias claims. So let's learn a little bit more about this case. The en banc Fifth Circuit Court of Appeals on Friday revived a lawsuit claiming that Dallas County, Texas, required female jail guards, but not men, to work at least one day each weekend, and therefore overruled a longstanding precedent that federal anti-discrimination law only prohibits bias in ultimate employment decisions, such as hiring, promotion, and settling pay. So this was a issue that the Fifth Circuit said before, okay, we only think discrimination on the basis of sex applies to ultimate employment decisions, which, doesn't make sense compared to the Civil Rights Act. So the Fifth Circuit said, okay, yeah, we've been wrong all this time, which they were. The precedent had imposed a more strict standard than Title VII of the Civil Rights Act itself, which applies to any terms, condition, or privilege of employment. It's no wonder that no other court of appeals applies so narrow a concept, the Fifth Circuit wrote. So yeah, the Fifth Circuit basically had been screwing this up for decades. Title VII says you can't discriminate as relates to any term, condition, or privilege of employment. So that isn't just the decision as to whether or not to hire. That isn't just the decision as to whether or not to fire. That isn't just the decision as to whether or not to promote. That isn't just the decision as to whether or not to pay. That is every decision. That is all the decisions. It is all the things. Any term, any condition, any privileged benefit of employment, anything. You can't discriminate on the basis of sex. So if you want to say that, women have to work one day a week, then, the men also have to work one day a weekend. If you say women must work one day a weekend, then men must work one day a weekend, unless you can point to a specific reason that you are discriminating on the basis of sex. So maybe you can point to a bona fide occupational reason, right? So maybe you can get past this, maybe, but, in the first instance, you have to be equal as it relates to sex, which is fair enough. And the circuit has just recognized this apparently for the first time, just having discovered this is law, which it clearly was. The lawyer for the plaintiff says the ruling makes clear that Title VII prohibits to any workplace discrimination, which it does by its own terms. The Dallas County District Attorney's Office did not immediately respond to comment because they lost. The 9 female correctional officers who sued Dallas County were backed by the U.S. Department of Justice, which filed an amicus brief. The Department of Justice urged the Fifth Circuit to adopt the rule that will apply to any terms and conditions because that's what the federal law says. I mean, this is just a straight reading of the law, guys. I mean, I don't know what the Fifth Circuit, why it had a bug up its ass, because it just clearly says that in the text. Yeah, any term of condition of employment. Yeah, you can't discriminate on the basis of sex. If you want to discriminate on the basis of sex, you're going to have to prove that you have a reason. You can't just do it for the hell of it. Dallas County had acknowledged it as a sex-based scheduling policy for jail guards, but maintained scheduling is not an ultimate employment decision, which, it's not. So Dallas County's like, yes, we were discriminating on the basis of sex, but it doesn't matter because we weren't trying to fire them. And the Fifth Circuit's like, yeah. The 3-judge panel of the Fifth Circuit, of course, affirmed the case law because they had no choice, but said the Fifth Circuit should overrule them, and then did. So the Fifth Circuit Court of Appeals is like, this is really, really dumb, but we have no choice. We have to do this because it's the precedent of our circuit, and we can't overrule the precedent of our circuit. So we are unfortunately required to say that, yeah, Dallas is right, and we think that's really dumb, and we really think the en banc should reverse this, and now they have. So great. On Friday, the Circuit Judge Edith Jones, in a concurring opinion, said it was unnecessary to overrule the court standard for approving the claims because Dallas County had admitted the scheduling policy was based on sex. Well, no, that's not the issue. The issue isn't, are we discriminating on the basis of sex? Apparently, the issue was, are we discriminating on the basis of sex in a way that matters? And apparently, we had determined it didn't matter, which was really dumb. Also saying that the ruling failed to be the precise level of minimum workplace harm they must allege. The majority's incomplete ruling leaves the bench bar and employers no clues to what this court will finally decide as the minimum standard for Title VII liability. Well, I mean, the statute itself says pretty clearly, any workplace benefit, any of them. So the injury can be slight if it's on the basis of sex. So what's the minimum standard? I don't know, $1? De minimis harm? You can't discriminate on the basis of sex and any condition of employment unless there's a bona fide occupational reason, which there might be, but you have to actually, show that. So if you have a bona fide occupational reason, then great. If not, then not so much. Thus, that brings us to the end of this case by the en banc Fifth Circuit, which just, read the law, which it clearly says in Title VII, you can't discriminate on the basis of sex and any term or condition of employment, which, means all of them. Any sort of benefit, any sort of program, any sort of anything. You can't discriminate on the basis of sex unless you have a bona fide occupational qualification. So there are some things that you might be able to discriminate because only men or women can do that job, which, fair enough. Like if you want to say that only women conduct the women's strip searches or only men conduct the men's strip searches, then cool, right? That makes sense as a bona fide occupational qualification. Only women can do this particular job because of the reason I just said just now. That would be fine. And so if you can show that a reason that's a bona fide occupational qualification, then cool. Then you might be able to discriminate, but you can't discriminate just, for the hell of it. So here they're like, how about women work the weekend, but men don't? And they're like, that's really dumb. Why do women have to work the weekend and men don't? And Dallas is all over here like, it doesn't matter. We can discriminate all we want. Duh, 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 duh. And Fifth Circuit's like, no, you can't. And then some judges on the en banc are like, well, where does it stop? And I'm like, well, it stops when you stop discriminating on the basis of sex other than in a bona fide occupational qualification. I mean, just follow the statute, man. So where is the bare minimum? I don't know. If you do anything, if you make the women stay, 5 seconds longer than the men because they're women, then, don't do that. You do it because they're women. You're not allowed to do that either. The women must stay 5 seconds longer. Why? Because they're women. Oh, it's so minimal. It doesn't matter. It matters. You can't do that. So yeah, that reverses a long, stupid ruling of the Fifth Circuit. So discrimination on the basis of sex continues to be illegal. And that for the moment brings us to the end of discussion of this story.